Hey everybody, so I get asked this a lot. What's the difference between a provisional and a non-provisional patent application? I am JD Houvener, founder and owner here at Bold Patents Law Firm. Also an inventor advocate for the past 10 years, helping inventors get over 500 patents as of today. I'm excited to talk with you about this topic of discerning the difference between a provisional patent application and a non-provisional patent application. They're both utility applications. That's one thing really to note. And a utility application is one of three major types. All right, a utility is what you probably think of when you're imagining an invention, which is something either physical, tangible, or has a method or process to it, which is how software is protected. And it provides a benefit, right? A utility, that's where the name comes from, right? A real functional benefit. And that's what it rewards too. The inventor gets a functional claim. They get to protect the way something works, right? How it does, right? What the benefit, the functional aspect. And that's what the claims are, the written claims at the end of a utility patent. That is what the owner of the inventor gets for up to 20 years. They get to exclude everyone else from making, using, selling, or importing that invention. Now, the other two types are design and plant patents. Design patents don't cover functionality. They cover the aesthetics only, the way something looks and feels. And plant patents cover the botanical plant structure of a novel plant species. So sticking with utility patents, there are two types within that. That's a provisional, which is a much more informal filing and more of a placeholder, and a non-provisional, which is the final formal application that the USPTO examiners will look at and review. Now, which one makes sense for you right now will depend on your circumstances. A provisional, for the most part, costs less to hire an attorney to help you with because it's less involved. You don't need to have any formal claims, nor do you have to have formal drawings. The specification does need to be written and thought out. Your description of your invention should be enabled. And what that means is it has to be described in so much detail so that someone in the some of ordinary skill in the art, in the field of invention, could see what you've written and put in some of the drawings as well, and they can actually go make and build it. That's how much detail you have to have in your invention disclosure so that your attorney can draft the specification, the written description of what will become the provisional patent application. Now, the cool thing is with both, you get patent pending status. And you don't need to say, hey, I'm patent pending with a provisional only, or I'm patent pending with a real non-provisional. No, it's just two words, patent pending. The catch here is, though, the provisional will only lock in that priority date, meaning that date you first filed that application, the first application, for up to 1 year. So 1 calendar year with no exceptions, you've got to file that non-provisional patent application. So if you want to keep it alive, you have to file that usually get started around the 9 or 10 month mark to make sure it's really well written. Now, here's the major benefit of filing a provisional. If this is your first time going through it, especially as you're developing your product, is you have that time to iterate, to go prototype, maybe even sell your product within that first year and come up with changes. While they may be subtle, you can add more detail into the specification that will make up a more refined claim set. Because in the end, what you want to have is a patent claim set that matches the product that you're selling. I see it often where patent applications get filed, and while it's pending, because it can take a year or two or more to get prosecuted, meaning the examiners get assigned to it, it takes a long time and many months, then they have to do their own search, examine it, and then finally get back to you. So that long period of pendency, products slowly change and move on to versions 2 and 3 and 4. And unfortunately, the product now, while it's selling well on the market, no longer matches what you have a patent for. So don't make that mistake. Do as much iteration and design change as you can while it's still pending with the provisional, so you can put all that detail in at the non-provisional level. So hope you appreciate the differences here between a provisional and a non-provisional utility patent application today. I'm JD Houvener with Bold Patents Law Firm. Have an awesome day today. Go big, go bold.